This presentation provides legal information about renting homes in Hawaii. It summarizes important information about housing law to prepare your family for your housing search. This presentation is brought to you by the Legal Aid Society of Hawaii, the state's oldest, largest nonprofit law firm. We have 10 offices statewide with over 100 staff members. Call today if you need assistance for civil legal issues at 808-536-4302, press option 1, or go on our website at www.legalaidhawaii.org for online resources or to submit an online intake. Any information provided in this presentation is legal information. Legal information provides you with general facts and rules. No client and attorney relationship is created through the viewing of this video. An overview. There are two main types of housing: public housing and private housing. Public housing is where the landlord is the government, like the Hawaii Public Housing Authority, or HPHA. Examples of public housing include Towers of Kuhio Park on Oahu, Kahale Mua on Maui, Hale Olaloa on Hawaii, and Hale Ho'onanea on Kauai. HPHA has a list of public housing locations on its website. A tenant's rent is set at 30% of their income. There are usually income limits for these housing projects. Public housing sets rent at 30% of a person's income. Every year, public housing checks the person's income to adjust the rental amount. If a person's income decreases during the year, the person should report the income to lower the rent. However, the person is not required to report increases in income during the year. For example, John earns $1,000 per month. He pays 30% of his income in rent, so he pays $300. John's income drops to $900 per month. He reports his income change to public housing. Public housing changes his monthly rent to $270 per month, $900 times 30%. Besides public housing, there is private housing. Private housing includes apartments and homes rented by owners. Ads for these types of housing can be found in newspapers and on the internet. Rent is determined by the landlord and tenant. Note there is no rent cap in Hawaii. Some tenants may qualify for rental help to pay for private housing. For example, Section 8 vouchers pay a portion of the tenant's rent directly to a private landlord. The tenant pays the leftover rent. The tenant has lower costs, while the landlord is guaranteed a portion of his or her rent from the government. The landlord and tenant need to follow the Section 8 voucher regulations to keep the voucher. For example, a tenant needs to find a rental unit within 60 days of moving out of a current unit. You will need to apply for a Section 8 voucher on the government website. Private housing follows different rules from public housing. Private landlords and tenants follow Hawaii's Residential Landlord-Tenant Code. It describes landlords and tenants' rights and responsibilities. You can find this handbook on the Department of Commerce and Consumer Affairs website. The address is https://cca.hawaii.gov/ocp/landlord-tenant. Important note: because Section 8 voucher tenants live in private housing, Section 8 landlords and tenants must follow the Hawaii Landlord-Tenant Code. Both public and private housing must follow the Fair Housing Act. There are state and federal laws that protect tenants from discrimination under the Fair Housing Act. Under federal law, tenants are protected against discrimination by their sex, race, color, religion, disability, familial status, and national origin. In Hawaii, we have additional laws that protect tenants against discrimination based on age, ancestry, HIV status, Hanai status, marital status, gender identity, gender expression, and sexual orientation. Starting in May 2023, landlords cannot discriminate someone based on receipt of Section 8 subsidies. Discrimination can happen when a landlord refuses to rent a unit to a tenant based on one of those categories. For example, a landlord discriminates against familial status by stating he or she does not want kids in the unit. If you would like to report a complaint against a landlord who violates these protections, please call legal aid at 808-536-4302. Now that you understand the general rules about rentals, I will discuss how to prepare for a housing search. For public housing and Section 8 applications, applicants apply directly to the agency or housing project. Agencies include the Hawaii Public Housing Authority and Honolulu City and County Section 8 offices. Due to the demand for this assistance, housing projects and Section 8 usually have wait lists. Sometimes the wait lists open for new applicants. If you are interested, please contact these offices. Many public housing have closed wait lists, so people need to wait until they open to apply. You can check the public housing websites such as hpha.hawaii.gov. These announcements are usually posted in the newspaper and sometimes announced in the news. Public housing provides a small window of time to apply. For example, HPHA opened its waitlist for several projects and allowed people from July 11th to 15 to apply. Be prepared with names, dates of birth, social security numbers, and an email. Check your email and respond timely to requests for information. Most of these applications are done online. If you need an interpreter, they will provide one. Private housing search is different from public housing. Here are some tips. Tip 1. Assess your budget. Set aside 1/3 to 1/2 of your monthly income for housing and utilities. This will help you determine how much you can afford for monthly rent. Tip 2. Search for housing options online. You can look at different websites and conduct internet searches. Tip 3. Start gathering information about your rental history and landlords, your work history, personal references, and emergency contacts. This information may be required on the application. Tip 4. Contact the landlord to schedule a viewing. Show up on time or let the landlord know if you are late. Dress appropriately. First impressions make a difference. The landlord wants to know that you are appropriate and dependable. Tip 5. At the house viewing, do a thorough inspection. Check the faucets, stovetop, toilets, windows, and cabinets. If things are broken, request that these things be fixed. Be respectful. Be honest and answer the questions asked. Don't tell your whole life story. Remember, there may be multiple applicants for one unit. Tip 6. Landlords look for complete applications, supporting documentation, and application fee. Here are some tips for completing the application. Complete the entire application. Don't leave anything blank. Put NA if does not apply. Turn in all requested documents. Turn in supporting letters if needed. For example, if you have criminal background, ask your probation officer to write a letter on how great you are doing. Include your application fee. In this tough rental market, there may be multiple applicants applying to the same unit. If you are denied, ask the landlord why you were denied. Then fix the issue and apply to another unit. Persistence is key. If the landlord accepts your application, the landlord gives you a lease. There are two types of lease agreements, written or verbal. A written lease agreement is signed by both the tenant and landlord to rent housing for a period of time at a set price. The term ranges anywhere from month to month, 6 months, or 1 to 2 years. These fixed-term lease agreements specifically state when the lease ends. If you do not have a written agreement, you and your landlord have a verbal lease agreement. Verbal agreements are usually treated as month-to-month leases. The Hawaii Landlord-Tenant Code applies to both types of lease agreements. It is highly recommended that you get a written lease to make sure you and the landlord agree to the same lease terms. Here is a copy of a standard written lease agreement. The beginning of the lease clearly lists the state and federal protected classes that landlords may not discriminate against. The first page of the lease also includes check boxes to note if the written agreement is a fixed-term lease or a month-to-month lease. When the landlord agrees to rent the unit, the landlord usually requests a security deposit from the tenant. Security deposit is additional money held by the landlord to ensure that a tenant will fulfill the terms of the lease agreement and that they will leave the rental in good condition. Security deposit can be up to 1 month's rent. A pet deposit can also be charged, limited to 1 month's rent. As a result, a tenant can pay up to 2 months' rent for security deposit and a pet deposit. Note that service animals and emotional support animals are not pets. A landlord cannot charge a deposit on these animals. A security deposit cannot be used for the last month's rent unless the tenant has an agreement with the landlord in writing. Do not forget to request a receipt. During move-in, check everything. Write a detailed list of furnished items and note any damage. Report problems that need to be fixed to the landlord immediately. Make sure both the tenant and landlord sign the checklist. Take pictures or video of your unit before moving in. Report repairs in writing as soon as possible to your landlord. Make sure to date your requests and keep a copy for yourself. Your landlord has 12 business days to start repairs after they receive your written notice. If the repair is an emergency, the landlord must start repairs within 3 business days. Some emergency examples are major appliances, plumbing, or hot water problems. There is an exception if the damage was done due to misuse by the tenant. You may only request repairs once every 6 months. The repairs cannot cost more than 3 months' rent. If the landlord does not fix the problem, the tenant has the right to repair the damage and deduct the cost from their next month's rent. This amount cannot exceed $500. Because repair and deduct situations are difficult, please call legal aid at 536-4302 for assistance before you take action. Important: in Hawaii, you don't have the right to withhold rent from the landlord. A late payment is a violation of your lease agreement and reason for eviction. Always pay your rent on time. Terminating your lease. A tenant may terminate a month-to-month lease for no reason. A tenant must give the landlord 28 days written notice for a month-to-month lease. On a fixed-term lease, the lease ends at the expiration of the term. If the tenant leaves early, the tenant may be responsible for rent. For example, Joe's lease ends on March. He wants to leave in January. Joe may be responsible for rent for February and March because his lease does not end until March. The landlord may allow Joe to find another tenant to pay for February and March. Important note: Section 8 voucher holders need to be careful about terminating a lease early. Generally, they need to stay in one place during the first year of the voucher. They can terminate leases early if the landlords agree. However, they may lose their voucher or face other penalties. It is highly recommended that Section 8 holders communicate with their Section 8 workers about terminating a lease early before doing so. The Section 8 workers may have options for tenants in difficult situations, such as when tenants experience domestic violence. A landlord must give 45-day written notice to terminate a month-to-month lease. A fixed-term lease ends at the end of the lease. The landlord may also terminate leases early if the tenant violates the lease agreement, such as a tenant that disrupts the neighbors. A landlord must give written notice of the violation to allow the tenant time to correct his or her actions. If the violation is not corrected, the landlord can proceed with evictions. During move-out, the tenant is allowed reasonable wear and tear on the unit. The tenant should try to schedule a walk-through inspection with the landlord before the move-out date. After the tenant moves out, the landlord has 14 days to return the security deposit. If the landlord does not return the entire deposit, he or she must send the tenant a written notice explaining why they are keeping part or all of the deposit. If the landlord retains a part of the deposit, they should provide an itemized breakdown of the costs. The landlord must send a letter within 14 days of the tenant moving out. If the tenant feels that the landlord has wrongfully withheld the deposit, they have 1 year from the lease termination date to file paperwork in court to recover the security deposit. When a landlord wants to evict a tenant, the landlord must follow eviction proceedings in district court. This is actual court. A landlord must provide written notice to the tenant and file documents in court. A landlord and tenant usually appears in court. The judge may order the parties to mediation. Mediation is a process where a third party tries to help two parties reach an agreement. If mediation does not work, the parties may go to trial. After a trial, the judge could issue an order to evict the tenant. Important note: if you have a Section 8 voucher and you are evicted, you will lose your Section 8 voucher. Section 8 vouchers are high in demand. This is why it is recommended that you mediate an agreement with the landlord before the landlord gets a court order to evict you. Victims of domestic violence and their immediate family members have protections under the Violence Against Women Act. First, they may terminate a lease early with proper notice. The violence must have occurred 90 days from the date that the tenant notifies the landlord. The tenant must give 14 days notice prior to terminating the lease and include proof of domestic violence. There is no penalty or liability for future rent after the early termination date. Second, if the tenant does not choose to terminate the lease early, he or she may request the landlord to change the locks. Third, a court may order the domestic violence perpetrator to leave the unit. The perpetrator cannot access the unit unless a policeman accompanies him or her. Here is an example of early termination. On September 1st, 2020, Mary moves into a unit with a 1-year lease. She is dating Joe. On September 15, 2020, Joe punches Mary. On September 20th, 2020, Mary obtains a temporary restraining order against Joe. On December 14, 2020, Mary writes to the landlord that she wants to terminate her tenancy on December 31st, 2020. She attaches the restraining order. On December 31, 2020, Mary terminates the tenancy. The landlord must release Mary from the tenancy. The landlord cannot charge her any more rent from December 31, 2020. Public housing evictions are different from private landlord-tenant. First, the public housing agency must have good cause to evict the tenant. Good cause means serious or repeated offenses, such as non-payment of rent, pet violation, or health and safety risks. The agency cannot evict a tenant for no reason. Public housing also follows an administrative appeals process, which is not court. Public housing evictions follow administrative processes. These processes are handled by agencies like the Hawaii Public Housing Authority. This is not court, though it may feel like court. A tenant may attend a grievance hearing, eviction board hearing, and an appeal hearing before commissioners before getting evicted. Remember that public housing evictions require good cause, such as rule violations. Public housing tenants and Section 8 voucher holders have additional protections through the Violence Against Women Act, VAWA. This act protects a person from being evicted due to domestic violence. This can include a spouse, parent, brother, sister, or child living in the unit. This also protects the family members of the perpetrator from eviction. Victims can seek emergency transfer to a different unit. There are limitations to the VAWA protections. A landlord can still end the tenancy for other reasons. A landlord can also end tenancy if there is actual and imminent threat to other tenants. In closing, here are some best practice tips. Before you move in, read the lease. Document the condition of the rental. When you move in, always pay your rent on time. Report anything that needs repair. Be a good neighbor. Communicate with your landlord. When you move out, inform the landlord in advance. Clean the unit and remove all your belongings. Complete a walkthrough. Ask for your security deposit if you do not receive it in 14 days. This concludes the Housing Readiness presentation brought to you by the Legal Aid Society of Hawaii. If you have a legal issue regarding housing, please call 808-536-4302 or visit us at our website, legalaidhawaii.org, to complete an online intake request. Thank you.